Number 1. Camia Hassel.
911.
I need help. My husband was shot.
It was New Year's Eve 2018, and Army Sergeant Tyrone Hassel III had just returned from a family gathering in St. Joseph Township, Michigan. He was 23 years old, a young husband, a devoted father, and a man known for discipline and responsibility. But as he stepped outside that night, he had no idea he was walking straight into a plan designed by the person he trusted most, his own wife. Camia Neka Hassel was only 22 at the time. On the surface, she seemed to share the same disciplined life as Tyrone. Both were in the Army, stationed at Fort Stewart in Georgia, and both were raising their infant son together. To friends and family, they looked like a solid young couple, hardworking, ambitious, and building a life rooted in service. But behind that image was a growing fracture, one that would eventually cost Tyrone his life. The trouble started with an affair. Camia had begun secretly seeing another soldier, Jeremy Cuellar, while Tyrone was still faithfully building their future. The affair might have remained hidden, but instead it turned into something darker. Camia and Cuellar were not just sneaking around, they were plotting. According to investigators, she confided to Cuellar that Tyrone's life insurance could set them up for good. The combination of money and the desire to be with her new partner became the motive for murder. On December 31st, 2018, the plan unfolded. Tyrone had been celebrating with family, enjoying food and laughter, before heading back to base the next day. As the night wore down, he stepped outside the home, unaware that Cuellar was waiting in ambush. Shots rang out, and Tyrone collapsed. Neighbors heard the chaos, but by the time help arrived, the young sergeant had died at the scene. What seemed at first like a sudden, senseless act of violence was, in fact, the product of weeks of secret conversations. The investigation began immediately. Police noted that nothing was stolen, which made robbery unlikely. As detectives dug deeper, inconsistencies in Camia's story raised suspicion. She appeared calm, even detached, during questioning. Soon, messages and phone records revealed a troubling trail. Exchanges between Camia and Cuellar that pointed to more than just an affair. They detailed the logistics of the murder, where to wait, when Tyrone would be outside, how it should all unfold. This was the turning point. Investigators confronted Cuellar, who eventually confessed to being the gunman, but he didn't keep the blame to himself. He explained that it was Camia who had orchestrated everything, promising him a future together once Tyrone was gone. That confession cracked the case wide open. What had looked like an outside attack was revealed as a conspiracy from within Tyrone's own home. By April 2019, Camia Hassel was formally charged with first-degree premeditated murder and conspiracy to commit murder. Prosecutors laid out the story in court, a calculated betrayal driven by lust and greed. The defense argued that Cuellar was the actual killer, but the prosecution showed the jury the planning, the coordination, and the cold decisions Camia had made to see her husband dead. Witnesses described her behavior after Tyrone's death as disturbingly emotionless. The trial painted a chilling portrait. Prosecutors emphasized that Tyrone had trusted her completely. He had been focused on his duties, on supporting their child, and on their shared life as a military family. In contrast, Camia had been envisioning a new life without him, funded by his death benefits and free from the responsibilities of their marriage. On August 29, 2019, the verdict came back. The jury found Camia Hassel guilty on both counts. The sentence was life in prison without the possibility of parole. She was just 22 years old when the cell doors closed behind her, and she will spend the rest of her life in prison. Cuellar, who had pulled the trigger, took a plea deal and received a reduced sentence in exchange for testifying against her. The case left Tyrone's family shattered. His father, Tyrone Hassel II, spoke about the loss not only of his son, but also of the life Tyrone was building for his young child. Friends and fellow soldiers remembered him as someone with integrity, discipline, and a future that was abruptly stolen. For them, the betrayal cut even deeper because the crime wasn't just committed against Tyrone, it was committed by the woman who had vowed to stand by his side. Today, Camia Hassel remains behind bars, serving life without parole. There are no appeals or parole hearings on the horizon. The story comes full circle with a sobering reminder. Behind the image of a picture-perfect young couple was a plan that ended in tragedy, not only taking a promising life but leaving behind a child to grow up without either parent. The betrayal of trust, the lure of money, and the willingness to destroy everything for desire. Those were the ingredients that turned a marriage into a case studied nationwide. And in the end, justice sealed her fate. Number 2. Susan Lawrence. It was a warm evening on June 2nd, 2023 in Ocala, Florida, when tensions between two neighbors finally boiled over. For years, small disputes had been simmering between 59-year-old Susan Lawrence and her younger neighbor, 35-year-old Ajika A.J. Owens. That night, the feud came to a violent end when a single gunshot was fired through a closed front door. A.J. Owens, a devoted mother of 4, collapsed in front of her children. To understand how it came to this, you have to look back at the relationship between Lawrence and the Owens family. Susan Lawrence lived alone in her home, while A.J. was raising her kids in the same neighborhood. Neighbors said there had been tension for months, often over something as simple as children playing outside. Lawrence was described as easily irritated, quick to complain, and prone to confrontations. A.J., on the other hand, was remembered by her family as a hard-working, loving mother, someone who worked tirelessly to give her children stability. But her protective nature often meant she would confront issues head-on, especially when it came to her kids' safety. On June 2nd, that cycle reached its breaking point. According to investigators, an argument had sparked earlier that day. Lawrence accused the Owens children of making too much noise near her property. Words were exchanged, tempers rose, and by evening, A.J. walked over to Lawrence's door to speak directly. What happened next would stun the community. Instead of answering, Lawrence fired her gun through the closed front door. The bullet struck A.J., who collapsed in front of her children, who had followed her to the house. Emergency responders rushed to the scene, but A.J. died before she could be saved. The case immediately drew public outrage. This wasn't a confrontation between strangers, these were neighbors. And the fact that the fatal shot had been fired through a closed door raised urgent questions. Why had Lawrence pulled the trigger when there was no immediate threat? Police quickly began investigating, interviewing witnesses, including A.J.'s children who had seen the shooting unfold. Lawrence was arrested and charged with manslaughter, along with counts of assault connected to endangering A.J.'s children. Investigators uncovered that this wasn't a sudden reaction. There had been a history of complaints and altercations between Lawrence and the Owens family. Prosecutors would later argue that the killing was not only avoidable but reckless and unjustified. As the case moved toward trial, the legal process highlighted two very different perspectives. The defense portrayed Lawrence as a frightened woman, claiming she felt threatened by repeated confrontations and fired in panic. They suggested she acted in self-defense even though she never opened the door. The prosecution countered that argument with hard facts. A.J. was unarmed, the door had remained closed, and the children themselves were witnesses. They emphasized that firing through a barrier without even confirming a threat was an act of aggravated manslaughter. The trial in 2024 was closely watched, not just in Florida but nationwide. It raised larger debates about neighborhood disputes, firearm responsibility. Family members of A.J. Owens testified about the devastating loss of a mother who had been the center of their lives. Neighbors described the long-running tension, showing that this tragedy had been building for some time. The jury heard evidence about Lawrence's state of mind and her prior complaints, weighing whether her fear was reasonable or if it crossed into reckless disregard for life. On November 25, 2024, the verdict was delivered. Susan Lawrence was found guilty of aggravated manslaughter. The judge sentenced her to 25 years in state prison, making it clear that the decision to fire blindly through a door had taken an innocent life and would carry heavy consequences. Today, Lawrence sits in a Florida prison serving her sentence. She will be in her 80s before she is eligible for release, effectively spending the rest of her life behind bars. For A.J.'s family, especially her children, the sentence brought a measure of justice but could never replace the presence of their mother. The case of Susan Lawrence and A.J. Owens stands as a sobering example of how neighborhood disputes can spiral into irreversible tragedy when fear and frustration are mixed with firearms. A simple choice, to open a door and talk or to stay silent, was replaced by the pull of a trigger. And in that instant, two families were destroyed, one by loss and the other by imprisonment. Number 3. Nicole Cristina Aguilar. The hotel room was quiet after midnight, the kind of quiet that feels staged. Curtains drawn, AC humming. Everyone's supposed to be asleep. But in late July 2021, inside an extended stay near Fort Sam Houston in San Antonio, a choice was made that would unravel a family, trigger a multi-state search, and end in a courtroom where a mother would testify against the man she'd chosen over her child. Nicola Cristina Aguilar was 25, a young mother who had recently moved to Texas. Friends and relatives would later describe a woman eager to make a new start with her boyfriend, Daniel Garcia. Prosecutors said the relationship became the axis around which every decision spun. Both had children of their own. Both were trying to put together a blended life. But the picture never matched the reality behind closed doors. The weeks leading up to the crime were marked, prosecutors said, by discipline that was neither ordinary nor safe. Garcia's treatment of 5-year-old Dominic Patrick Aguilar Acevedo escalated. Strikes to the body, face, isolation, withholding food. It was a steady climb from control to cruelty, and according to investigators, Nicole saw it, knew it, and did not intervene. That omission would define the case as much as the violence itself. Then came the night that changed everything. At the extended stay, Dominic was beaten in a way from which he could not recover. He was a small child in a room that should have been safe. He did not get medical help. The next hours were the pivot. Instead of calling 911, the adults focused on what to do next. And that choice turned a deadly assault into a larger crime. Discovery did not happen in San Antonio. It happened hundreds of miles away. In early August 2021, a child's remains were found in a Colorado ravine. Investigators traced the path back to Texas and then to a mother and her boyfriend who had left the state after the boy died. What followed added shock to grief. Evidence showed that after the death, the couple transported Dominic's body from Texas to Colorado and disposed of him in a remote area before leaving the country. The investigation moved quickly once the trail formed. Texts, travel, and witness statements built a timeline. Authorities said the pair fled to Costa Rica. When Nicola was questioned, she admitted what had happened and who had done what in that San Antonio hotel room. The question for prosecutors became not whether Dominic died by violence, but how to allocate legal responsibility between the person who inflicted the blows and the person who failed to act. By 2024, the legal pieces were in place. Prosecutors charged Daniel Garcia with killing a child and charged Nicola with injury to a child by omission. Texas's way of saying a caregiver's. Failure to protect can be a crime with the gravest consequences. As Garcia headed toward trial, the state offered Nicola a deal: plead guilty, testify truthfully against him, and face a cap of 15 years in prison. In return, a separate tampering count would be dropped. On May 8, 2024, she accepted the plea and agreed to testify. Sentencing would be delayed until after Garcia's trial. The courtroom sequence that followed was tense and methodical. Jurors heard how a 5-year-old had been disciplined into silence, how a caregiver watched and chose not to seek help, and how a journey to Colorado tried to hide what had happened in Texas. At the end of May 2024, the jury found Daniel Garcia guilty of injury to a child resulting in death. 2 months later, a judge sentenced him to life in prison, a measure of the court's view of the violence in that room. Then it was Nicola's turn to face her own sentence. In August 2024, after her testimony and after Garcia's conviction, a Bexar County judge imposed 15 years, the maximum allowed under her plea deal, for injury to a child causing serious bodily injury by omission. The court also dismissed the tampering charge consistent with the agreement. The message from the bench was unmistakable. Failing to protect a child, when you are the person who must protect him, is a crime with real time. The case leaves stark contrasts. On one side, a child's short life, 5 birthdays, a handful of school days, and a future that should have included bikes, friends, and cartoons. On the other, 2 adults and 2 separate roads to prison. One for the person who used his hands, the other for the person who used silence. Prosecutors framed it in simple terms: duty and choice. A duty owed to a child, a choice not to act. There are lingering questions that no sentence can settle. Why didn't someone pick up a phone sooner? Why did a caregiver let fear of losing a relationship outweigh fear of losing a child? The court's record cannot answer those fully. What it can do is mark the outcomes in ink. Garcia, life in prison. Aguilar, 15 years under a plea that required her to tell the truth about what she saw and did not stop. As of today, Nicole Cristina Aguilar is serving her sentence in the Texas state system. She will be in her late 30s when she first sees the possibility of release. The case stands as a harsh lesson about omission. In the eyes of the law, not doing something can be as devastating as doing the worst thing. And in this story, the silence after midnight was not a pause. It was a decision that cost a life. Number 4. Sarah Boone. It starts with a suitcase on the floor of a Winter Park apartment, the kind you'd pack for a weekend away. On the night of February 24, 2020, 42-year-old Jorge Torres Jr. climbed inside as part of what began, at least in the story told later, as a game after drinks. Hours later, he was gone, and the question of how play turned into a fatal trap would follow this case for years. Sarah Boone was also 42, living with Jorge in that small Florida unit. Friends knew them for their on-again, off-again turbulence. Police knew the address too, but when officers arrived, February morning, Boone said it was an accident. They'd been fooling around. Jorge got into the suitcase. She fell asleep on the couch, and by the time she remembered, it was too late. Her tone in the interview would be debated for months, but the core claim, forgetfulness, not intent, was the point she wanted on record. Then investigators found the phone videos. They weren't long, and they weren't ambiguous. Recorded minutes apart, they showed Jorge zipped inside the suitcase, calling out that he couldn't breathe, pleading to be let out. A voice identified as Boone's responded from behind the camera. Those clips changed the gravity of everything. What had sounded like an accident now looked like a choice made in real time. For the jury later, they would become the pivot. Here's the step-by-step as the state reconstructed it. After the suitcase was closed, Jorge struggled. Instead of unzipping it, Boone filmed. Instead of calling for help, she went upstairs. At some point, the apartment fell silent. By morning, Jorge was unresponsive. The autopsy focused on oxygen deprivation and injuries consistent with being confined. From a small apartment to a crowded courtroom, the picture sharpened. A confined space, a narrowing of options, and a failure to act that prosecutors would call malicious. The investigation moved quickly in the first days, then slowed to a crawl as COVID delays, attorney withdrawals, and hearings stacked up. Boone wrote letters to the court. Lawyers came and went. Trials were set, then reset. In the background, one detail lingered. Before trial, Boone had declined a plea agreement of about 15 years. It was a decision that would hang over the case like a clock you can't stop hearing. When the trial finally opened in October 2024, the central conflict was stark. The defense told jurors Boone had lived in fear, pointing to cycles of conflict and claiming she reacted out of trauma. The state answered with the recordings, the autopsy, and a timeline that left little room for panic or mistake. In opening statements and expert testimony, prosecutors focused on intent inferred from action, zipping, filming, leaving, sleeping. The question wasn't whether Jorge died in the suitcase. It was whether Boone's conduct showed a depraved mind under Florida law. A mini cliffhanger came late on a Friday. After closing arguments on October 25th, the jury retired. They didn't take long. In under 2 hours, they returned, guilty of second-degree murder. The courtroom readout was quiet, then final. For a case defined by delay, the verdict felt sudden, like a door closing. Sentencing didn't happen that day. That's an important correction to the headlines some people remember. The judge said it over. On December 2nd, 2024, Orange County Judge Michael Kranick imposed life in the Florida Department of Corrections. The court also noted Boone had refused that earlier 15-year deal. For the family in the gallery, it was the first day since 2020 when the process felt finished. For Boone, it was the day the apartment door was replaced by a prison gate. So, what were the investigative turning points that got them there? First, the digital evidence. The videos were the spine of the case. Second, the physical context, the closed suitcase, the lack of timely aid, the autopsy. Third, statements and behavior, from the initial "we were playing" explanation to the absence of a 911 call when it mattered most. Each piece alone might leave room for doubt. Together, they formed a straight line. The defense tried to bend that line. They raised the specter of a toxic relationship, of prior harm, of a mind under strain. Jurors listened, carefully by all accounts. But Florida's second-degree standard asked whether actions showed a reckless disregard for human life. To the panel, the recordings and the timeline answered that. In interviews afterward, coverage emphasized how quickly the jury agreed once they reached the room. It wasn't the drama of a whodunit. It was a "why didn't you?" After sentencing, Boone was transferred from the county jail to a state facility to begin her life term. Appeals were signaled, as they almost always are in a case with this much publicity and pretrial churn. But the essentials are fixed. Winter Park, February 24th, 2020. Verdict October 25th, 2024. Life sentence December 2nd, 2024. Those dates bookend a story that began with a late-night recording and ended with a courtroom calendar page. If you're looking for a single image that captures the case, it's not the suitcase itself. It's a smartphone screen glowing in a dim room while someone inside begs for air. That gap between what a camera sees and what a person chooses to do became the moral center of the prosecution. And it's where the law finally settled. Not on what was said afterward, but on what was done and not done in the moment that mattered. Sarah Boone is serving life in Florida's prison system. There's no parole on a life sentence in that jurisdiction. Jorge's family keeps the memory of a son and brother whose last words were captured on a device meant to connect us. The apartment is quiet now. The suitcase is just an object. But for everyone tied to this case, the silence after those recordings will always feel loud. Number 5. Julissa Angelica Genrich Thaler. The stop was supposed to be routine. Early on May 20th, 2022, police in the west metro suburbs of Minneapolis pulled over a car with a shattered rear window and a spare tire clattering in the trunk. Minutes later, officers opened that trunk and found what would end a custody fight, ignite a statewide reckoning, and send a 29-year-old mother to prison for life without release. Before that morning, Julissa Thaler's life had been defined by conflict and instability. Friends and officials described long struggles around mental health and a turbulent relationship with the father of her 6-year-old son, Eli. Just days earlier, after months of back-and-forth hearings, she had regained full custody. To people who knew the family, the decision felt precarious. To the court, it was final. Eli went back to his mother. The hours that followed were the hinge of the whole story. Investigators later said Eli was shot inside his mother's car in a parking lot not far from Lake Minnetonka. The weapon was a shotgun. He was a first grader with a wide grin and a backpack full of drawings. The contrast between the ordinary setting and the irreversible harm became the prosecution's quiet refrain. No chase, no intruder, no stranger in the night. Just a child in a car with someone he trusted. Discovery and investigation began at the roadside, then moved quickly. Officers noticed blood on Julissa's hands and clothing and what looked like body tissue in the vehicle. She offered explanations at the scene, claims the officers documented and later disproved. The bullet damage, the shells, and the forensic trail led back to her car and forward to the trunk. What might have been a missing person search became a homicide case in a matter of minutes. As news spread, documents painted a fuller picture. Prosecutors alleged a deliberate act following a bitter custody fight, while the defense suggested gaps and alternative possibilities. But certain facts didn't move. Eli's body was found in his mother's trunk. A shotgun was recovered, and the medical findings were consistent with multiple close-range shots. A Star Tribune report later noted the indictment's detail that he had been shot up to 9 times. Each point narrowed the lanes for reasonable doubt. Charges came fast. In late May 2022, Julissa Thaler was arrested and charged with second-degree murder, then later indicted for first-degree murder. The legal theory was straightforward. A parent in sole care of a child, a firearm, a timeline that tracked from custody to killing to concealment. Prosecutors prepared to argue premeditation through actions rather than words, weapon choice, location, transport, and efforts to mislead. The defense countered that no one had actually seen her pull the trigger and suggested others could be responsible. That argument would reach a jury but would not carry it. Trial opened in early 2023. The courtroom was packed with family members, reporters, and people who had followed the custody proceedings with mounting concern. The prosecution put the investigative sequence on rails. Patrol officers, crime scene techs, medical examiners, and digital and physical evidence that tied the events to Thaler's movements. The defense tried to slow the train, pointing to the lack of a direct eyewitness, raising questions about state of mind, and suggesting the enduring chaos around the family meant answers were less certain than they seemed. Jurors listened, took notes, and asked none of the outwardly dramatic questions, just the kind that show they're building a careful timeline. On February 8, 2023, the jury returned a verdict: guilty of first-degree murder. With that finding, Minnesota law set the consequence almost automatically. In this state, a life sentence for first-degree murder means no parole, no release. 8 days later, on February 16, 2023, a Hennepin County judge pronounced the sentence: life in prison without the possibility of release. For Eli's father, Torrey Hart, and the people who had warned for months that something might go wrong, it was accountability, but not relief. Even after the verdict, the case kept echoing. Local stations and investigators laid out the missed red flags, warnings to county services, concerns raised by relatives, and a custody decision that now read like a countdown. In late 2024, Dakota County agreed to a multi-million-dollar settlement with Eli's father in a wrongful death lawsuit, an acknowledgement from the system that the safety net had torn. The courtroom process had answered who and what. The civil resolution wrestled with how and why it wasn't prevented. Today, Julissa Thaler, full legal name, Julissa Angelica Genrich Thaler, is serving life in the Minnesota state system. There is no parole date to mark off on a calendar. Eli's family has spoken less about punishment than about remembrance. A bright 6-year-old who loved to draw, a boy who should have been starting second grade when his case went to trial. The final measure of the legal process was certainty. The remaining burden is memory. If there's a single through line, it's escalation. A long custody struggle, a series of warnings, a split-second act that could never be undone, and a verdict that was decided in days but built over months of evidence. The cliff's edge in this story isn't a whodunit. It's the moment people asked if anyone would step in and what happened when no one did. That's where the narrative stops for the criminal case and begins for the rest of us, looking back at the signals that didn't change the outcome. Number 6. Elizabeth Archibek. On the afternoon of March 2, 2020, officers in Flagstaff, Arizona stepped into a small apartment and caught the first cold draft of what had been happening behind a closed door. A 6-year-old boy was unresponsive. He was thin, quiet, and beyond help. His name was Deshaun Martinez. Within hours, a timeline began to take shape that would end with a rare sentence in Arizona: life in prison without the possibility of parole. Elizabeth Archibek was 26 at the time. To neighbors, she was the mother of several children, living with their father, Anthony Martinez, and Martinez's mother. Inside the home, prosecutors would later say, discipline had been twisted into deprivation. The picture that emerged was not of a single bad night, but of a pattern: food withheld, hours of confinement, and a punishment that moved from strict to cruel. The background matters because it explains the small details investigators kept finding. The closet wasn't a metaphor. Detectives and later jurors heard that Deshaun and an older brother were locked for up to 16 hours a day in a tiny bedroom closet, a space so confining that the smell told part of the story. They were kept there for weeks, punishment for trying to sneak food when the adults were asleep. An autopsy recorded the last number of the child's short life, about 18 pounds. For a first grader, it was a number that defined the case. How did it all come to light? The call for help brought officers and medics, but not in time to save him. What they saw led to a search, statements, and a widening circle of witnesses. The details were consistent in a way that made the case unusually direct. The closet, the withholding of meals, the length of the confinement. From the moment detectives started writing, the investigation felt like a straight line rather than a maze. There were early turning points. One was the medical examiner's report, which gave the case the stark label of homicide and cataloged the signs of prolonged malnutrition. Another was the living condition of Deshaun's siblings. 2 boys had clear signs of deprivation, the younger girls. In the home were not in the same condition. That contrast strengthened the allegation that this was targeted punishment, not household poverty or a sudden crisis. Each new fact deepened the conflict at the core. Adults in charge of safety had become the source of danger. Legal process began almost immediately. In 2020, Elizabeth Archibek and Anthony Martinez were charged with first-degree murder and child abuse. The paternal grandmother, Ann Martinez, faced related child abuse counts. As pretrial hearings stacked up through the pandemic years, the prosecution kept its filing simple. This was planned through conduct, locking, rationing, denying, and continuing after warning signs appeared. The defense would have little room to argue accident or confusion. In May 2023, Archibek made her decision. She pleaded guilty to first-degree murder and child abuse, admitting the conduct that the investigation had already sketched. For the state, the plea meant no trial. For the court, it opened the door to the harshest penalty available short of death. The judge set sentencing for July. The case had moved from what happened to what is the consequence in a matter of pages. On July 27, 2023, in a Coconino County courtroom, the sentence was pronounced life in prison without the possibility of parole. Witness statements described the closet, its size, its smell, its role as a tool of control. The judge called out the length and deliberateness of the conduct. There would be no parole calendar to mark, no chance to ask for release. For a mother in her 20s, the rest of life would be spent in the Arizona Department of Corrections. The case didn't end there. In May 2024, after a full trial, a jury convicted Anthony Martinez of first-degree murder, child abuse, kidnapping, and assault on officers. A month later, he received his own life sentence. That sequence confirmed what the state had argued from the start. This wasn't a tragedy that happened to a family. It was a set of choices made by the adults in it. The criminal record now bears both names and 2 life terms. Why did jurors and judges see intention in a case without a single planning text or confession of motive? In the law, intent can be built from actions. Locking children in a closet for most of each day for weeks, systematically denying food, ignoring visible decline. Those acts became the roadmap to premeditation. The slow build led to the shocking reveal. A 6-year-old who weighed as much as a toddler, a child whose world had been reduced to a dark rectangle on a bedroom wall. The fallout was the rest of the docket: pleas, verdicts, and life sentences. There are cliff edges throughout this timeline. One is the moment someone could have made a call earlier. Another is the line between strict and cruel, a line that the court said was crossed again and again. And there is the difference between silence and action. In this case, silence was not neutral, it was part of the harm. That's what the judge signaled when imposing life without parole. The harm wasn't sudden, and so the punishment would not be brief. Today, Elizabeth Archibek is serving life in Arizona with no parole available. The legal story is complete for her. Appeals are not what decide a no parole life term in this state. For Deshaun's surviving siblings, the story is different. A long path of care and recovery beyond a courtroom's. Reach for the public, the case is a reminder that some dangers don't announce themselves with noise. Sometimes the quiet places are the worst ones. Number 7. Gail Eastwood Ritchie. Before sunrise on a cold March morning in 1993, two newspaper carriers drove a quiet country road in Gauga County, Ohio. They spotted a plastic bag near the ditch, pulled over, and made a discovery that would haunt the county for decades. A newborn boy, later buried under the name Joga's Child. From that moment, a small rural mystery began. Who was the child's mother and what happened in the hours before he was left in the woods? The backstory didn't surface for 26 years. In 1993, detectives worked the usual angles, but there were no hospital records, no missing infant reports, and no witnesses who saw a frantic young woman the night before. The coroner said the baby had been born alive. The cause of death was undetermined violent cause. There were signs the body had been outside and exposed, and investigators were careful in their language about what happened afterward. All they could say with certainty was that a living infant had been placed in a bag and left in a wooded area off Sidley Road. The community paid for a funeral and carved an epitaph that read like a promise to a stranger. Years passed. Detectives retired. The grave marker became part of local memory. Then the technology changed. In 2019, a sheriff's detective used consumer genealogy data to build out a family tree. Names, branches, distant cousins, and narrowed the list until one person stood at the end. Gail Eastwood Ritchie of Euclid, Ohio. When officers approached, she acknowledged the connection. She was arrested and charged nearly 3 decades after the roadside discovery. The break wasn't a tip. It was the new science of genetic genealogy, the same toolbox that had reshaped other cold cases across the country. That's where the conflict truly began. Prosecutors described a young woman, 22 at the time, who secretly delivered a baby, placed him in a bag, and left him in the woods. The defense countered with a different frame. A frightened caregiver who believed the child had been stillborn, raised in a strict household, overwhelmed and ashamed. The jury wouldn't be asked to decide whether she was a model citizen in the years that followed. They would be asked what happened that night in 1993, and whether leaving a living infant to the elements was a criminal act under Ohio law. The investigation had turning points beyond the genealogy. In 2019 interviews, Eastwood Ritchie told detectives something the jury would never hear. Years earlier, as a teenager, she had disposed of another newborn in a field in Cuyahoga County. A judge later ruled that statement too prejudicial to present at trial, but it would echo at sentencing. For detectives, it affirmed a theory that this was not a sudden, impossible-to-foresee tragedy. It was a decision made before, then made again. Trial began in early April 2022. The state walked jurors through the old photographs, the coroner's findings that the child had been born alive, and the timeline that led from a secret delivery to a wooded pull-off. The defense leaned on doubt. No video, no confession saying the baby was breathing at the moment she walked away, and a defendant who had, by then, lived an otherwise quiet suburban life. The question the jury had to answer was narrow but weighty. Did the conduct meet the elements of murder as charged? After about 5 hours of deliberation, they said yes. Guilty of murder, not guilty of aggravated murder. Sentencing came the next month. On May 24th to 25th, 2022, Judge David Andre imposed life in prison with the possibility of parole after 15 years. The standard term for this degree of murder in Ohio. He spoke directly to the explanation that fear and youth had driven the act, noting Eastwood Ritchie's statement about a prior infant and calling the pattern impossible to ignore. For the community that had named and buried Joga's child, it was a conclusion written in clear legal language. Life with parole eligibility after 15 years, not a finite term. There's a detail here that often lands like a mini cliffhanger. The case was solved by a third cousin's DNA. It wasn't a direct match in a government database, but a careful build-out from distant relatives who had uploaded to a public site. From there, the detective drew a 1,400-name family tree, then narrowed it to the Euclid address where the knock on the door finally happened. It's the kind of modern investigation that turns chance into a roadmap. Appeals followed, as they usually do. In May 2023, an Ohio appellate court reviewed the record and described the original 1993 findings with clinical precision. The tiny body, the autopsy, the ruling that the infant had been born alive, and left the conviction standing. Later in September 2023, the state Supreme Court declined to take the case. The trial verdict and the sentence that followed remained intact. Where does that leave the story now? With a timeline that begins on March 25, 1993, when a baby was found on the roadside, jumps to June 2019, when a detective used a new kind of family tree to find a mother, lands on April 5, 2022, when a jury said guilty of murder, and settles on late May 2022, when a judge pronounced life with parole after 15. The headstone for Giauga's child still carries the message the community chose years earlier. Too late to save his life. Too late to make things right, but not too late to teach us all to love and cherish life. For decades, the case was defined by silence. A nameless child, an unknown mother, a bag beside a road. The resolution came from voices that didn't exist in 1993, distant relatives' data points and a detective's patient mapping. And in court,